Ms. Morgan, you can have a seat with Ms. Fowler. We'll have a deputy here to retrieve you. Thank you.
Your Honor, could you please discuss what we're supposed to do with the CPAP? Just let her die?
I have no idea.
Ooh, guys, I got a high stakes one for you today. This repeat DWI offender steps in and the judge absolutely unloads. No more excuses, no more second chances. The past catches up fast and the consequences get real in seconds. This escalates quick and gets intense as the judge lays it all out. You won't believe how hard this one hits. For nonstop courtroom drama and daily uploads, subscribe to Daily Courtroom Drama. Now let's jump into it.
The case of P. Cheryl Morgan. Case number 23S18956FH.
Oh, yes, the cane defense. She'll soon learn that that will not do her any good in this courtroom.
For sentencing, provide Constantine with a notice and copy of the defense right to a photo.
I do have a lot to say on this one, Judge.
Okay.
I'm sure you're used to it.
Mr. Butler, can I give you back this, is this,
The information on Casey?
no, the exhibit, but maybe this was in the file. You didn't give that to me. You didn't give this to me today, did you?
I
No,
just picked up
we
there.
did.
It's Casey.
For Josh Casey. Yeah.
Okay, I'll give you that back and I'll give you this back.
Oh, thank you.
All right, now I can get that right file here. So who do we have, Ms. Constantine?
Cheryl Morgan, Your Honor.
Morgan, all right. All right, then Ms. Constantine, if you had an adequate opportunity to review the pre-sentence report and the sentencing information we declined.
I have, Your Honor.
Additions, corrections, or deletions.
Yes, Your Honor.
All right, what do you have?
OV3. She was
Okay.
given 5 points for an injury. There was no injury. So I'm asking the court to put that at 0. If you read the police report, which I have.
I don't get the police report, so let's see what the description says.
Was
And
resist.
let's start with Ms. Bond. Did you do this one?
I did not. Agent Hibbett did, but I'm reviewing your report.
I can point, Your Honor.
Go ahead.
Okay.
Your Honor, on page 3 of the CFJ 284, so with in the description of the offense narrative,
Mhm.
The first full paragraph there, it states in the middle, it addresses OB3 and OB19 directly. The 2 officers gained control of the defendant, where she ultimately was handcuffed, and she said, quote, "I'm going to kill you." Cheryl then proceeded to kick the officer in the shin, OB3 and OB19. So that was the basis for scoring OB3 and OB19.
And I'm aware, Your Honor, of what the police report says. But if you read through the police report, there is no talk of an injury at all. If someone pinches you and you don't get a bruise, that's not an injury. The officer said she kicked him. If she had, then he would have put in the police report. Miss Morgan kicked me and now I have a bruise. But none of that was done, Your Honor. None.
What do you mean? The PSI says that she kicked the officer in the shin.
I understand that, but they're reading it from the police report, and the police report says that she did kick him in the shin, but why is that an injury? Do you see anything anywhere that he received an injury?
Well, OV5 says bodily injury not requiring medical treatment occurred to a victim.
OV5,
And
about 3,
scoring, I'm sorry, OV3, 5 points is what I meant.
correct.
And bodily injury is not an element of the sentencing offense.
And I agree with that, Judge.
Okay.
I've
So
reviewed this.
your argument is there was no bodily injury, whether it required treatment or not.
That's my exact argument.
Okay, well, Mr. Butler, what do you think about that argument?
Actually, I think that, pain or exhibiting some kind of, or having some kind of pain does support being injured. And I think that in kicking the shin, obviously there's some kind of feeling associated with that. So with that, I think that's 5 points up.
All right. It is an interesting question. Don't know that it's one that has been made before the court before. 12B3 does require bodily injury, even if it doesn't require medical treatment. Now, I concur with Mr. Butler that getting kicked in the shin may be painful, even though it wouldn't necessarily require treatment. However, getting kicked in the shin might also not cause anybody to incur any kind of pain. And then does pain or lack of pain then relate to bodily injury? And that's an interesting question. But there's not anything in here, and I certainly don't have an impact statement unless the probation or Mr. Butler does.
No, there isn't any.
From an officer that indicates here's the bruising or here's something else that would suggest a bodily injury. So Ms. Costigan, I'm gonna grant your objection because I don't know that there's enough to sustain the 5 points. So that'll be scored at 0. What else do you have?
Well, I have allocution, but that's the
Scoring
one
issue.
change that I wanted made.
That's the only scoring issue?
Yes,
All right, so that takes a total of E from 40 to 35.
yes.
Does Ms. Bond, does that change our level from?
I think it does to 10.
It doesn't.
It does.
No, it's still a level 4. I think we're between 35 and 49 points, still a level 4.
So it remains 5 to 23.
So it still remains 5.
All right.
All that effort just end up back at the same place with the same potential sentence and the same consequences. Man, that must be frustrating.
So no other objections then, Ms. Constantine?
Your Honor, I do have objections, but it would be a waste of your time
Okay, but what
because
do
you
you,
will argue with me.
let me ask, objections to scoring, any other objections?
No,
Okay, and then, because we started with that, I'll go back to, kind of threw me off here. Mr. Butler, did I go to you as far as anything on behalf of a victim or people?
You have not yet.
Okay,
So, Your Honor, I think the PSI lays out a lot of information about the defendant's past and what maybe is precipitating all of this, but nevertheless, we're still left at the end of the day with someone who is putting on her own safety by the passenger of the vehicle and anybody else on the road in danger. She's a .18 in this instance. This is her fourth OWI. Not sure if the injury to the passenger was a result of the crash or something that happened prior to. That's not really fleshed out in the police reports. The defendant did decline ITASK. She did not want to be part of that. Which was not referred to that. The recommendations case is 150 days jail plus probation. We have a lot of the same issues maybe that presented in the last case. Your Honor sent this someone out earlier today.
you mean Ms. Fowler?
Yes.
Okay, but the difference with this is there's a guideline that is more appropriate for somebody in a similar situation.
Yeah, definitely. Maybe not the same, obviously not the same degree of alcohol intoxication as the prior defendant, but certainly.
Once
very
more priors,
Very concerning, more priors, yes.
for 24 years ago.
right?
And I know that it got changed for the 10-year rule. I know that. I read it.
But that's one of the reasons the 10-year rule was changed, right? Because people that drink alcohol in particular can have long stretches of sobriety. But then when you don't have that hint of supervision, if you will, whether it be non-reporting probation, whatever the case may be, then they go out and they drink and drive, and that's when individuals get seriously hurt or killed, right, Ms. Constantine?
Yes, Your Honor.
Yeah.
And as you can read in there, that she wasn't driving at first. They got lost, so then she did. And as far as Mr. Butler's statement,
Mhm.
that.
Well, he hasn't finished yet, so I have to go back to him, but
Okay.
you can finish your thought if you'd like, as far as the statement was.
As far as his statement regarding the injury, the person testified that he had fell during the day.
Mm.
So he's here if you want to ask him.
I don't need to ask him, because I don't
Okay.
think anything was scored regarding injury to another individual
No.
other than the officer. And
And-
again, that might be a police report thing, but I don't think that's contained in the PSI.
No, it wasn't in the PSI, but it was just brought out. That's why.
Okay, all right,
That's
Mr.
why.
Butler, I didn't mean to cut you off, but anything else?
Yeah, no, thank you.
All right, Ms. Constantine, elocution on behalf of your client.
Yes, Your Honor. I know you've read the PSI, and my first argument is it's 24 years. My second argument is Miss Morgan has so many health problems. My biggest issue is CPAP. If you don't use the CPAP, then you stop breathing. And I really don't want to open the Ionia News and find out my client died because she didn't have her CPAP machine. The jail does not allow that. I've already called them and asked them. So I am asking this court to place her on a tether for whatever, 90 days, 6 months, whatever the court feels. But this is a person that she's having surgery the 8th. She goes back to find out what date it is. And she can't walk. She has nerve problems. She has millions of that. But my biggest issue is the CPAP. You can't, well, you can do anything, obviously. But my whole problem with this is if she dies, and she would with a CPAP, without a CPAP machine, that's why I'm asking the court to put her on tether.
All right, anything else, Ms. Constantine?
No, Your Honor.
All right, then Ms. Morgan, did you have anything that you want to state to the court before a sentence is imposed?
I'm sorry for everything. But I don't want jail because I have to go. I just had an EMG done, so I need to go get results the 8th, and then he'll set up surgery for my back or I won't be walking. And he just put plates in my neck, and the back of my neck has to be redone.
Okay,
And I'll do anything I can if I don't have to go to jail.
all right. Well, Ms. Morgan, if you were here earlier when I sentenced Ms. Fowler, there are plenty of similarities, but there's plenty of differences. And I'll say this, at the end of the day, when I review Ms. Fowler's sentence, I'll say a couple things that jump out at me that are very different.
Right.
At one point, Ms. Fowler was absolutely serious about sobriety, and I believe Ms. Fowler can do that again. She has a lot of insight when she's in the right place in her life and doing the right things with the right people. She has apparently fallen off the wagon. Your case is different though. She only has 2 priors. You have 3 priors. Your bodily alcohol content was 0.18. And here's the big difference. While I have faith in her moving forward, I do not have faith in you. You adamantly opposed ITASC. You then, as I read through the PSI, and then with your attorney's comments here today, you use your physical condition, and I'm not unsympathetic to your physical conditions, saying that, well, I'm not going to be able to do community service because I just have these physical limitations. Well, I can't really do jail because I have these physical limitations. Then you go on to say that transportation is going to be a problem for you because your significant other works long hours. Everything in this PSI that was floated by you is in fact a barrier or an excuse as to why you can't do anything that would ensure that the public is protected from you, the drunk driver. That's much, much different than the other individual that I just sentenced. The other thing that I note when we go to this is a 4. And I will say, when I read the PSI, and we've touched on this as far as the guideline scoring, Ms. Morgan, this is pretty common. You may not know that because you don't have to sit through these dockets every day. But often people will come to court and they'll espouse one thing that's very different than how they live their life. Your case, it's like, I've got all these physical maladies. I can't do X, Y, and Z because, oh boy, my physical condition. But what did we just read in the PSI? Well, your physical condition did not prevent you from driving under the influence that day. In other words, it didn't prevent you from obtaining and ingesting enough alcohol to be a 0.18. Your physical conditions did not prevent you from fighting with the officers, pulling your arms away, making a fist, telling them that I'm going to kill you. Your physical condition, whether it caused injury or not, didn't prevent you from kicking an officer in the shin, right? So it's kind of is hard to buy when I hear today, Judge, boy, this problem I have and this problem, I just can't do any of that because of my physical condition, but I can kick a police officer. They don't go together, do they? And I have a tendency to believe when one is able to be out there not facing the music, so to speak, not here to be sentenced, that the closer version of the truth is the person that can tense up, ball up their fist, pull their arms away from the police and kick them in the shins. That would suggest much more physical, being much more physically robust than what is being presented to the court this morning. And then regardless, whether that's accurate or not, the facts of the matter are this is a 4th and you were a 0.18. And then maybe the most important difference between now and the other individual I sentenced earlier, Ms. Fowler, your guidelines are 5 to 23. So they are guidelines that are much more specific. And I can't believe that nobody mentioned this to the court today, but the court has made a note of it. I've said over and over and over, I'd like to start at the middle and then go up or down based on what's appropriate in the PSI. 14 months is the middle of the guidelines. This is now a 5th time individual that has been drinking and driving. And there's no doubt that Ms. Constantine's correct. When we go long periods of time, 4th time today, this is the 4th one. When we go long periods of time, that's the very thing that society can't solve. Individuals with a drinking problem often are the most successful on supervision. For whatever reason, several people, many people with drinking problems can kind of almost go cold turkey. They're model probationers. And then the minute they graduate, they're down in the local bar drinking. It's kind of an interesting phenomenon. Nobody seems to look at it. But the problem with that is we have these long stretches of no criminal activity. I would tell you that statistics would bear out the idea. Just because you went that long between convictions doesn't mean that you were not drinking and driving. That just means how long it was before you got caught. Because it would be an incredible coincidence, wouldn't it, Ms. Morgan, that the one time that you drink and drive with a gap of 10 years is the one time you get caught?
The judge is right. Statistically, that's not likely. Now, that being said, someone that continually drinks and drives, I hate to say it, does kind of build up a certain tolerance and is less likely to be involved in an accident than someone that's, first time getting hammered behind a wheel. But still, neither great choices, both terrible ideas.
Everybody knows that's nonsense. But the fact of the matter is, here we are, 4th offense today, 3 priors, a 0.18, and a guideline range that is 5 to 23. I'm not interested this morning with you, Ms. Morgan, particularly with everything that you've had in this PSI that you don't have any interest in ITAS. You're not interested in addressing your alcohol problem. You don't think that you have an alcohol problem. You tell me you can't do community service. You're not interested in that. You're not interested in complying with any sort of supervision because you have these transportation issues. It's excuse, it's excuse, it's excuse. Not once have you referenced to probation that I'll do this or I'm going to do that. It's all what I can't do. And then you have a pretty bold argument today that, well, I shouldn't do any jail. How is that going to protect the community from your drinking and driving? How is that going to serve as a deterrent to others? How would this court look when a fourth offense drunk driver gets no jail time? How does this court look if I even entertain that and then you're out 6 months from now, a year from now, 2 years from now, and you seriously injure or kill somebody? They don't care about your argument or Ms. Constantine's or the prosecutors. The only person then that looks like an idiot is the court, because they're going to go back and say, well, what was her sentence? And I guess that idiot judge, 4 times now she's been convicted, and he allows her back into the community where she can then endanger or kill somebody again. Well, you can roll your eyes, but it happens every day. And Ms. Morgan, I don't need to hear anything from you. You've already had your opportunity to speak. So you can roll your eyes, but that's exactly what happens. And guess what? Ms. Constantine, Mr. Butler, and I would not be employed if we didn't have folks like you that reoffend. And I kind of wish that I didn't have that job, because once somebody, if there was a magic cure, you got an alcohol problem, you got a drug problem, we could fix it, that'd be fantastic. I would gladly go find something else to do for a living. Because honestly, this gets kind of old. The carnage, the damage, the death as a result of people that drink and drive, that use drugs, that commit crimes while using drugs, commit crimes to obtain drugs. And you're no different. And we've got a guideline range in a criminal history and a fact pattern here that all suggests that the sentence that I'm going to impose is appropriate. So, Ms. Morgan, I am required to impose a $130 crime victims assessment. That's required by statute. The court will do that. I am required to impose, not required, but I am going to impose court costs of $550. I'm required to impose state costs in the amount of $136. And that is broken down $68. Right, was found on accounts 1 and 2. And then Miss Constantine, I'm going to eliminate 32. You retain, is that right?
Yes.
All right, so the court will eliminate 32. I'm also going to impose a $1,000 fine. And then as it relates to count 1, now this is the operating while intoxicated. Ms. Morgan, the court's going to impose a sentence of 13 months with the Michigan Department of Corrections to the statutory max of 5 years. You will receive credit for 2 days you previously served. On count 2, the court's going to impose a sentence of 6 months to statutory max of 2 years. You will receive credit for 2 days that you've previously served. 1 and 2 will run concurrent, one with the other. Now, Ms. Morgan, you do have a right to seek appellate review of the sentence the court's just imposed. If you'd like to do that, you have 21 days from today's date to make that request. If you want a court-appointed attorney to assist you, you have a broader window of 42 days. So 21 and 42. Ms. Constantine, do you have the appellate paperwork there? So for the record, I'm placing the executed paperwork in the file. Anything else from either side?
No.
All right. Ms. Morgan, you can have a seat with Ms. Fowler. We'll have a deputy here to retrieve you. Thank you.
Your Honor, could you please discuss what we're supposed to do with the CPAP? Just let her die?
I have no idea what to do with the CPAP. It's not the bailiwick of the court to instruct the jail or the Department of Corrections on how to manage the health conditions of their inmates. I have no jurisdiction to do that. I would never even entertain the idea that somehow I'm a medical expert to tell them how to handle the medical issues of their inmates. That's something that you're gonna have to take up with, I assume, the Department of Corrections if they can get her on the road today.
I don't know.
All right, Ms. Morgan, have a seat, please. What else do we have?
We're going to independent jail and call the case of People v. Arlo Sutherland.
Whew. Yeah, guys, we see how that went. Judge was not putting up with any of her BS or any of her excuses. She's getting jail time. That's what she deserves. Fourth of time offending, and like you said, she probably was drinking and driving that entire time. If you want to see more courtroom drama like this, make sure to like and subscribe to Daily Courtroom Drama, where we upload twice a day, and I'll see you on the next one.